Welcome to this licensing hearing. The item 1 on the agenda is to elect a chair for the hearing, and I understand that members would like Councillor Hook to chair the meeting. Is that agreed?
Agreed.
Thank you, members. I'll now hand over to the chair.
Chair, just to let you know you're on mute.
Sorry, I didn't realise. Start again. Right. Welcome to members, officers and participants in this remote hearing, and to those watching the live webcast at home. A recording of this hearing will also be made available to view on the Council's website. Item 2 on the agenda is introductions. I am Councillor Hook and I am chairing today's meeting, and Councillor Galvin, who is on the telephone, and Councillor Myers are also sitting on this subcommittee with me today. There is also a Democratic Services Officer, Fiona Young, and a legal officer, Victoria Wardby, in attendance during this meeting. Would the following parties in attendance introduce themselves and name any witnesses they have present? First of all, the licensing manager.
Good afternoon, Chair. I'm Leslie Cook. I'm the licensing manager and I'll be presenting the report.
And secondly, the review applicant.
Good afternoon, Chair. Ray Price.
Hello. And third, the premises licence holder.
Zoe Sinclair, premises licence holder for Tobacco by Ambiente on Walmgate.
Thank you very much. Agenda item 3 is declaration of interests. Do members have any interest to declare?
No, upside down.
No.
And Councillor Myers is shaking his head too, so that's all good. And I have not either. I'm going to propose that in the usual way, the press and public be excluded from the meeting during the subcommittee's deliberations and decision-making at the end of the hearing. This is because it considers that the public interest in excluding the public outweighs the public interest in that part of the meeting taking place in public under Regulation 14 of the Licensing Act 2003, Hearings Regulations 2005. Do members so resolve?
Agreed.
Agreed.
Thank you. Agenda 5, that's the minutes of the previous meetings. I know that Councillor Galvin and I were at that meeting. Councillor Galvin, do you agree that the members that meeting agrees with what happened? Those minutes agree with what happened?
Agreed.
Yeah, and so do I. So do we approve the meeting? The minutes, sorry, of the meeting?
Proven.
Approved.
Yeah.
Lovely. Thank you. So that's this agenda item 6 is the application, which is why we're all here. The determination of an application by Mr. Price for a premises license review in respect to the premises license held by Ambiente Tapas Limited for the premises at 59 to 63 Walmgate, York, Y017, 9 TY. So the procedure for the hearing is detailed on pages 1 to 6 of the agenda pack, except that the subcommittee will not announce its agenda after determination in a public online meeting today, but it will be circulated to all parties and published in short form by the Democratic Services Officer. A full decision letter will follow at a later date. So in summary, the running order of proceedings is that the licensing manager will first of all present present their report, and I will then invite each party one by one to ask the licensing manager any questions. Then I will invite each party in turn. Sorry, is someone wanting to say something, or is no? Okay, that's all right. Sorry, I just could hear other noises. This is then the licensing manager will, yes. Next, I will invite each party in turn to present their cases and call any witnesses, and each party will have the opportunity to ask questions after each presentation as directed by myself, and the subcommittee will also be able to ask questions of the parties after each presentation. Finally, the parties will each be invited to summarise their case, and the subcommittee will have an opportunity to seek any final points of clarification before it goes into private session to make its decision. So do all of the parties understand the procedure for the hearing for this meeting?
Yes.
So we're okay. Great. So we'll move on then to, could the licensing manager, Leslie Cook, please present her report?
Thank you, Chair. This is the application to seek the review of a premise licence in respect to 59 to 63 Walmgate, York. Premise licence number CYC 060429. The applicant with regards to this review is Mr. Raymond Price. The application relates to the licensing objectives, the prevention of crime and disorder and public nuisance, and a copy of the application can be found at Annex 1 of the report, pages 27 to 56. Since the agenda was published, the applicant has submitted further information which has been published as an agenda supplement. A copy of the premise licence granted on the 9th of April 2018 can be found at Annex 2, and this includes the approved layout plan of the premises, and that's from pages 57 to 69. A summary of the licensable activities authorised can be found at paragraph 5, pages 19 and 20. A copy of a map showing the location of the premises can be found at Annex 3 on page 71. I can confirm that the consultation process was carried out correctly. A response has been received from North Yorkshire Police to confirm that they are not submitting any representations. A response has been received from the Council's Public Protection section, and this should be classed by members as a representation, which is neither in support or against the review application. This representation can be found at Annex 4 on page 73. And the reason that their comment has been classed as a representation, as the Public Protection has been involved in a number of complaints regarding this premises, and they make suggestions that members may want to take into consideration. 3 further representations have been received from other persons, 1 in support of the review and 2 opposing the review. The list of representatives can be found at Annex 5 and their representations at Annex 6, pages 77 to 82. The Licensing Authority has received a number of complaints regarding this premises, which has resulted in engagement with the premise licence holder and written warnings been issued. A summary of the complaints can be found at Annex 7 on page 85. The committee has the following options when making your decision. Option 1, modify conditions of the licence. Option 2, exclude any of the licensable activities from the scope of the licence. Option 3, remove the designated premises supervisor. Option 4, suspend the licence for a period not exceeding 3 months. Option 5, revoke the licence. Since the agenda was published, the licence holder has also submitted some additional information which has been published as an agenda supplement. That's a brief overview of the report, Chair.
Thank you very much. Right. Now we move on to questions of the licensing officer. Do you have any questions, Mr. Price?
Yes, I have 3 questions for the licensing officer.
Okay.
Question number one, there would appear to be no submission from planning. Given that Ambiente are operating in breach of planning controls, I find this surprising. I have to ask, has a submission been sought from planning?
Planning are a responsible authority that are consulted on all licensing applications, and they had the opportunity to make any representations if they wanted to during the consultation process.
Have they made any representation was my question.
No, if they'd have made any representations, it would have been part of the report.
Okay, thank you. Chair, I have to note that given the complex arrangement regarding planning at this premises, specifically that the premises have been operating in breach of planning since 2018 and only has limited planning authority for the outside yard, I find it quite concerning that planning have made no representation, and I'd like that to be recorded.
I believe that planning is a completely different area and you have to do, I don't know, is there a legal person who can point me in the right direction with the planning rules?
I can assist you, Councillor Hook.
Thank you.
At this time, it's questions of the licensing officer. Everything
Okay.
that's been asked by Mr Price and everything that's been said by Ms Cook has been recorded. It's recorded on the hearing video, it's recorded in the minutes. So that's all fine. So the question at Councillor Hook is whether or not Mr Price has any further questions of the licensing officer.
Okay. So yes, what was your other questions?
Well,
You said you had three.
I would just add a point to that. There is a responsibility in the statement of licensing policy for licensing to consider planning's response. I fully agree that they are two separate processes, and I fully agree that the licence hearing has the opportunity to disregard or ignore anything submitted by planning. That is different from planning not making any representation. My second question to the licensing officer is, what procedure does the licensing authority have in place for dealing and addressing public complaints of public nuisance relating to a premises licence?
We deal with any complaint that's submitted to the licensing authority is logged. We consider the details of the complaint. Dependent on the nature of the complaint, we may consult with other responsible authorities. Sorry, Richard, did you want to say something?
Yeah, Chair, just to let you know that Councillor Galvin, although you can see him on screen, he's dropped off the telephone call.
Oh,
so at this point, he's unable to hear us, and I don't think we'll be able to speak to him. So I think it's probably prudent to... Councillor Galvin, can you hear us okay? No, he's not connected to audio. I think we need to dial him in again.
okay.
So I don't know whether we could try dialing him in now, or we could just take a short break whilst we get him in.
Okay.
So if everybody's happy, I'll just put up a holding screen and just pop you into the breakout rooms. And I just sort that out, and then until we sort out Councillor Galvin's technical issues, apologies for the delay.
Right, welcome back. We've now got Councillor Galvin back, so we can resume. I think when we lost Councillor Galvin, Mr. Price, you were just about to ask your second question because you said you had three. So if you'd like to ask those questions of the licensing manager. Mute. You're on mute. Sorry.
Sorry, I apologise. Thank you, Chair. I'll repeat my second question. What procedure does the licensing authority have in place for dealing with and addressing complaints of a public nuisance relating to a premises licence?
Oh no, don't say we've lost the licensing manager.
Hi. Just give it Leslie a moment to see if it clears up. Hi, Leslie, can you hear us? Okay. So it's Richard Jackson here on the technical side of things. I appear to be very, very busy today. Yeah, so Leslie does appear to be frozen. Just give her a moment. Yeah, it doesn't look to be anything that can be resolved quickly. So again, we'll go through the same procedure as before, where I'll pop up a holding screen, pop you in the breakout rooms, and we'll look to resolve the technical issue.
Right, hello, everybody again. I really apologise for that last technical hitch, and hopefully that will be it for this evening. Leslie Cook, did you hear Mr. Price's question about, actually, Mr. Price, could you ask your question again, your second question? I think that's easier. And you're mute. Mute.
Okay, thank you, Chair. My second question is, what procedures does the licensing authority have in place for dealing with and addressing complaints of a public nuisance relating to a premises licence?
Hello, Mr. Price. Can you hear me clearly?
Yes.
I can, yes.
Very good. The council, with regards to all complaints, we have a stepped approach. Dependent on the nature of the complaint, we may liaise with one of the responsible authorities. Again, dependent on the nature of the complaint, we may contact the premise licence holder just by telephone. We may contact them to say that we want to meet with them in person. We may issue a written warning. It all depends on the nature of the complaint and how we decide we're going to proceed.
Thank you. I just make the point that whenever I make a complaint about a public nuisance, it seems to leave the licensing authority and head to the Environmental Protection Unit, who bounce it back saying they only ever deal with statutory nuisance.
If the complaint is about noise, we would liaise with our colleagues in the Public Protection Service with regards to who's best placed to deal with it, because they've got more expertise in dealing with noise complaints.
Thank you. Thank you for your answer, but I would register that the Environmental Protection Unit have made it very clear on a number of occasions on receiving complaints that I have submitted to the licensing authority that they only deal with statutory nuisance and pass them back to the licensing authority.
And your third question?
My third question is relevant to the licence as amended by the minor variations. My question is, a new Annex 2 Condition 6 has been added to the premises licence through the minor variation process, agenda page 62. The new item 6, new condition 6 says there shall be a minimum of 10 seats provided in the outside area at all times when in use in order to prevent a need for vertical drinking. No such condition was proposed by the licence holder as a minor variation. Given this, it must be assumed that this new condition 6 has been imposed by the licensing authority. The licensing authority cannot impose its own conditions through a minor variation process. Did the licensing authority impose this new condition 6?
No, the police did.
You're not in a position to put, the police don't impose conditions on the licence. The licensing authority makes the licence. This is a condition imposed by the licensing authority.
The police, during the consultation process on the minor variation, mediated with the applicant for the minor variation, and it was agreed as part of the consultation process.
At the beginning of the hearing, we were told there was no representation from the police. It appears that the police have made representation.
They haven't made representation to the review application.
Okay, I understand your point. My point remains that the licensing authority issued the licence, not the police, and that the licensing authority have inserted into the licence a new condition 6, and this is not permissible under the minor variation process.
And your points will have been minuted as part of this meeting.
Thank you.
Right, thank you. Have you any questions for the licensing manager, Ms. Sinclair? Mute again.
No questions at this time, thank you.
Thank you very much. Do members of the subcommittee have any questions at this point?
No, I haven't.
No.
No. Okay, and nor do I. So moving on. So first, now we have the review applicant's presentation, for which will be 15 minutes. So I will invite Mr. Price to address the subcommittee in support of his application. And you can call any witnesses if you like, but I don't think there are any on the call.
Thank you, Chair. Thank you, Chair. Just on a matter of process, do you wish me to make my presentation before I question the licence holder?
Yes, you make your presentation and then the licence holder will make a presentation and then you'll have a chance to question them on theirs, same as she will have opportunity to question you on your presentation.
And then there will be the opportunity for a further summary.
Yes, indeed.
Okay. I will be asking questions of the licensing holder in the reverse order then, because the process I followed before is that the questions to the licence holder come before my presentation. However, hello?
Yes. Would you like to proceed?
Okay. Thank you. I have submitted a substantial document and evidence, including reference to points of law, to warrant my claim that there is a fundamental failure by both Ambiente Tappers Limited and the premises licence holder, the premises licence holder and the City of York Council to promote primarily licensing objective 3, prevention of a public nuisance, and to a lesser extent, licensing objective 1, crime and disorder. And also that, as previously expressed by the City of York Council, the outside area is not suitable for a licensed premises. I will add weight to that statement. At the end of this review, my expectations are that the business's ability to operate from within its internal premises remains unchanged. The outside area is removed from the premises licence, and by so doing, my residential environment and well-being have been restored to the position I enjoyed before the premises licence was granted, and that ultimately a public nuisance is removed. I wish to be very clear here on the definition of public nuisance. The term statutory nuisance has been constantly used by the licensing authority, the Environmental Protection Unit and Ambiente. I have never suggested a statutory nuisance has been created, only a public nuisance. Public nuisance is clearly defined in the Council's Statement of Licensing Policy, Clause 7.11. To paraphrase, a public nuisance is not narrowly defined and can include low-level nuisance affecting one person living locally. Issues will mainly concern noise nuisance. It is unfortunate that the Council has continuously chosen to hide behind the term statutory nuisance, while ignoring its own definition of public nuisance and its responsibility to deal with it. It is equally clear that Ambiente failed to grasp the meaning of public nuisance, considering this to be something that has to affect the public at large. Their submission, page 30. Today, I am not contesting the licence as it applies to the internal premises. I am only concerned with the use of the outside premises. For clarity, let us be clear about that area. I ask you to look at the illustrations labelled Outside Area 1, my supplement page 5, and Google Map, my supplement page 9. Outside Area 1 illustrates its position in relation to the surrounding and mainly residential properties. It illustrates that, contrary to popular belief, the outside area is not on Walmgate and is not part of Walmgate's commercial area. It is a small one-time rear garden of a 3-storey residential property. It also illustrates the cycle store removed earlier this year to create an area to accommodate the increased seating and the serving of alcohol, and that the very nature of its position, as surrounded as it is, will amplify all sounds made in the outside area. Google Maps illustrates the relationship of the outside area to the surrounding properties including St Denis Court, my premises. I now refer you to the illustration labelled Premises Plan, my supplement, page 11. This plan is correct as of earlier this year. It includes the cycle store in place from 2014 until only recently, when it was demolished and removed by Ambiente. I now ask you to look at illustration labelled Outside Area 2, my supplement, page 7. This illustrates the outside area being used by 18 customers. The maximum permitted by the varied licence is 20 customers, and planning permission restricts this use to 12 customers. It will be noted that planning permission is being breached here. It also illustrates that the area previously accommodating the cycle store is now being used to seat additional customers. This represents a change of layout. You will also see that this outside area has come to resemble an overcrowded beer garden. This is the site that the council has previously said, if licensed, would have an undue effect on residential amenity. It is now licensed. Concerning my residential environment and well-being, I have always sought a balance between my needs as a resident, particularly the use of my own outside space, and the needs of the business to operate. In an attempt to retain this balance, I have used the proper licensing and planning procedures. The same cannot always be said of Ambiente. Incremental changes to the licensing and planning conditions put in place supposedly to preserve my residential environment and well-being have been ignored, misused, and eroded. These incremental changes, when taken as a whole, represent a substantial shift away from their original purpose, to protect the residential environment and prevent a public nuisance. As a result, the balance of my needs and the needs of the business have significantly shifted in favour of the business. I am also of the view that there has been an ongoing failure of the council to recognise this shift and use its enforcement powers to address this. By the time Ambiente submitted an application for a premises licence, the council had already expressed concerns stretching back to 2014 about the suitability of this outside area as an unlicensed cafe for just 8 customers. And later, in 2016, the council documented that the outside area should not be licensed. Against this background of documented council concerns, Ambiente was granted a premises license. In acknowledging these concerns, Ambiente volunteered a number of conditions, both in its application and again at the hearing, and in order to prevent a public nuisance. These are shown in the original licence. I have provided a copy, my supplement, page 13. But to paraphrase, these conditions, and I emphasise that they were proposed by Ambiente, required that the number of customers using the outside yard would be restricted to no more than 12. This condition was also requested by the police licensing officer. That alcohol would only be supplied ancillary to the provision of food, that alcohol would only be supplied in the outside area at certain times, that the outside yard would be cleared of customers and closed by certain times, and that noise from the premises would not be heard at the facade of neighbouring noise-sensitive premises. That is not to say that the business must operate in silence or that I expect it to. It is to say that in order to obtain a premises licence, Ambiente committed itself to operating in a way that would not create a public nuisance. It was entirely Ambiente's responsibility to decide how this would be achieved, but the success of Ambiente's achievements could be measured against Ambiente's own volunteered condition. Ambiente clearly felt that shoehorning a licensed premises into the outside area, irrespective of the concerns expressed previously by both the council and neighbours, could be achieved without creating a public nuisance. It would, however, only be a matter of time before complaints followed about noise from the premises that neither Ambiente nor the conditions, particularly condition 25, could control. These complaints and their outcome, the majority relating to noise as being a public nuisance, are well documented in both my submission and the report of the Public Protection Officer attached to today's agenda. There have also been a number of complaints raised directly by myself with the licence holder. The outcome demonstrated by these complaints is not whether or not condition 25 has or has not been breached, but that it is not possible to operate a licensed premises from this outside area without creating a public nuisance. Which brings us to this hearing. The council have continuously defended their lack of action by suggesting that no statutory nuisance has ever been created in regards to noise. I agree. I have only ever provided information and facts to support a public nuisance complaint. Both the senior licensing officer and the licensing enforcement officer, without presenting any contradictory facts, have simply said that no license conditions have been breached. I find their response remarkable. Equally, a public nuisance should be treated as such, irrespective of licensing conditions. It does not require a licensing condition to either exist or be breached before the council takes action against a public nuisance or its perpetrator. The council simply chooses to ignore the public nuisance complaint. Furthermore, the council is in no doubt that a public nuisance is being created. The council's own public protection officer has said, and I quote, "It must, however, be noted that noise from customers' voices being audible at the complainant's property does signify that condition 25 is being breached, and as the noise is unwarranted to the complainant, that this results in the loss of amenity to them when trying to enjoy their outside space, and is covered under the definition of public nuisance." Page 73 of the agenda, last paragraph. I would add to this that Ambiente equally agree that a public nuisance is being created. I refer to their submission agenda supplement 2, page 23. They say, if the noise complaint relates to that generated from the courtyard, we would plead that at most, any noise can only be held to be at annoyance level, even to the most sensitive of complainants who only ever at reasonable hours of the day. I must ask, why do Ambiente think it is acceptable to annoy me with their noise, irrespective of the time of day? And as the noise is unwanted to the complainant, this results in the loss of amenity and is by definition a public nuisance. To this, we must now add the recently approved minor variations. I have already submitted to you that I am of the view that the revised guidance issued under Section 182 of the Licensing Act has, in this case, been ignored by the licensing authority. I do not make that statement lightly and have submitted detailed points of law to support my assertion. For this reason, and notwithstanding any other outcomes from today's hearings, all the minor variations should be removed from the licence immediately. However, if this hearing disagrees with that assertion, then we must consider the impact of those recently approved variations upon the promotion of the licensing objectives. That is, that the numbers of customers using the outside area has been increased from 12 to 20, a 66% increase. The layout of the outside area has been changed to allow for this. In consequence, the capacity for drinking alcohol on the premises has been increased. The timings for when alcohol can be served in the outside area has been extended. The requirement that alcohol should only be served ancillary to food has been removed. Up to 20 customers can now drink alcohol in the outside area without the need to eat. Hardly a restaurant, but a bar. Indeed, Ambiente now promote these premises as a Spanish tapas and sherry bar. My supplement, page 31, refers. Conditions to control a public nuisance have either been relaxed or removed. I ask this hearing to consider how can this be seen to be promoting the licensing objectives, and how, by ignoring on several counts the guidance issued by the Secretary of State, Can the licensing authority be seen to be promoting licensing objectives? Control by conditions has been relaxed to such an extent that they now prove to be ineffective. I have been misled by the council into believing that conditions would protect my environment, my residential amenity, and prevent a public nuisance. This has proved not to be the case. To summarise, I may be the one who has requested this review, but it is the actions of Ambiente and the City of York Council that have brought about this hearing. Fundamentally, it would be a challenge to any licence holder, even one more committed to promoting the licensing objectives than Ambiente, to avoid creating a public nuisance. You cannot operate this outside area and as a licensed premises while at the same time promoting the licensing objectives. I propose that along with the removal of the recently approved minor variations, the licensing area should be excluded from the premises licence and a public nuisance removed. Thank you.
Chair, you're on mute.
Typical, right. Okay, thank you, Mr. Price. I will now ask Miss Sinclair as the licence holder, invite the licence holder, Miss Sinclair, to ask questions of Mr. Price. And Miss Sinclair, do you have any questions for Mr. Price? You have 5 minutes.
I have no questions at this point. Thank you, Chair.
Okay, thank you. Do the members of the subcommittee have any questions for Mr. Price? Okay, Councillor Myers.
Thank you, Chair. Thank you, Mr. Price. I'd just like to ask you about your view of the recommendations of the technical officer in the public protection officer, page 74 in the report, where he does he recommend? I think he recommends the removal of condition 25, which is now condition 26, and replacing it with the middle paragraph of wording at the end of his comments. It starts: a documented noise management plan shall be submitted to and improved in writing, and it finishes to say that this would include a procedure for investigating noise complaints. I'd just like to ask you for your view on that recommendation.
Well, I think the recommendation slightly undermines what he's actually said in the body of his text. In the body of his text, he is quite clear in that he says a public nuisance is being created. He says that there is a public nuisance. In his recommendation, he indicates that it might only possibly be a public nuisance, and therefore I think his recommendation is inconsistent with what he has concluded as a public nuisance. The second point that I would make is that for a licensing condition to apply, it must be clear, it must be understandable, and its intentions of what it is to achieve, it must equally be clear, not only to people, knowledgeable people such as licensing authorities, but also to lay people such as neighbours. I'm of the view that condition 25 is very clear in what it sets out to achieve, and that condition 25 is enforceable. Indeed, at the licensing hearing, I made the point to the licensing officer that I did not believe condition 25 was achievable. Despite my mentioning this and raising it in my own objections in 2018, the licensing chair at the time agreed, put it into the license. And on the basis that it has been included in the license, despite my concerns, I must consider that it is enforceable. And as this is an enforceable condition, I disagree with what the officer has said, that it should be removed. I don't disagree with the idea that there should be a noise plan, but having said that, I have suggested in my own presentation that the licence should be removed from the outside premises.
Thank you. Have you any more questions, Councillor Myers?
No, that's it. Thank you.
Have you any questions, Councillor Galvin?
No.
No, and Councillor Myers has asked my questions, so we can proceed. Right, I will now ask Ms Sinclair as the licence holder to make her submissions and call any witnesses. Ms Sinclair, you will have a maximum of 15 minutes to present your submissions and call any witnesses.
Good afternoon, everybody. Just to give you a bit of a background to Ambiente, for those who haven't eaten with us before, we are a food-led business. We have no intention of operating a vertical drinking establishment, and we have operated without complaint from any other licence committee since, for the last 14 years. So to have one complainant make 14 complaints, I think says more about the complainant than ourselves. The warnings from Public Protection came in 2018 prior to us installing air conditioning. We held our hands up to Mr Price when he made representations to us, because we were opening a window at the time, because we found that once we were operating in summer conditions it was too warm. So we installed air conditioning in July 2018. Mr Price subsequently made a complaint about us installing air conditioning, but it wasn't upheld by the Public Protection because it can't be heard at the boundary. And that has, I hope Mr Price will agree, has mitigated any noise complaint from inside the building. So just to make that clear, that the warnings were in relation to the internal premises, not the external premises, and no complaints have been upheld for the external premises. If Mr Price would like to make the distinction between the two, that there has not been any complaint, there's been no proof of any public nuisance, and Mr Price is only one of in excess of 15 neighbours that are our close neighbours around the courtyard. It's a highly populated area. I will make the point again that this is not public nuisance. It is at the worst tolerable annoyance. Mr Price is not your average person. Our staff who have been with us for many years in some cases and work 45 to 50 hours a week live under fear of his complaints, him leaning over the balcony, filming, taking sound bites, and even our customers now as well, which, you know, I could be as conciliatory as the next person, but it's come a time that we need to draw a line under this, because we can't go on operating like this. We've had a hellish 18 months, 8 of which we've been closed. We had to reduce our capacity inside by 20 covers. We've tried to compensate on the outside. We only have to look at the photo that Mr Price has taken on page 7 of his submission to see that people are sitting down in an orderly fashion in the backyard. They're not a bunch of hellraisers. This is in keeping with this part of the city. We're in a vibrant city. This is a case of extreme NIMBYism by Mr Price. He's living in the city centre, going out shopping and using other people's restaurants, but he doesn't want it in his backyard. We are a good neighbour, and I just need a line drawing under this for my sanity and the sanity of my staff. And that's all I've got to say. Thank you.
Did someone just drop out then? I heard a funny noise. I hope not.
No, we've got everyone here.
Oh, good. That's right. Okay, thank you very much, Ms Sinclair. I think move on to, yes. Thank you. I will now invite the review applicant, Mr Price, to ask questions of you. Mr Price, do you have any questions for Ms Sinclair? You have 5 minutes.
Thank you, Chair. Yes, I do. I didn't come on this review for a character assassination. So my first question to Ambiente is, in your submission to this review, page 31, you refer to me as a serial complainer. in your presentation, you have just said that I have 14 complaints against me. According to the council's own records, I have logged 11 complaints in 2018, and this is less than 4 per year. 4 of these complaints have resulted in a warning letter demonstrating that such complaints are justified. Given this, why are you labelling me as a serial complainer?
Because as I've already explained, we've been operating for 15 years and you are the only person, other than the 2 other complainants, I'm sorry I was misrepresented that slightly, that have complained about us on any premises. And I will, for the benefit of the members, I will just say that those warning letters came before we installed air conditioning, and they were directed towards the internal premises, not the external premises.
Thank you for your response. It doesn't correspond to the list of complaints that I've submitted as my supplementary information supporting my claim that a public nuisance is being created. My second question, as part of your submission, you have included a copy of Facebook comments, page 37. Given that there is a process for making representation to this hearing and that this process is open to members of the public, what is the relevance of you submitting these Facebook comments?
It was with particular reference to the submission made by somebody that lives above the premises.
In which case, why did you include a raft of comments defamating my character?
They're public. Facebook, it's public. There's nothing, there can be no allegation of defamation made against me by publishing something that's in the public domain.
No, my point was there is a formal process open to members of the public to make their comments regarding your submission and in defence of your business, but they chose not to do so, but you chose to present their argument via Facebook.
This was made on, this is a screenshot taken from York Mix.
I think that this isn't going to help our decision at all, this cross questioning. So can we have other questions that are actually of the license relating to this license?
Yes, thank you, Chair. It may not help your decision, but I think it can't go undefended that my character has been assassinated in Ambiente's presentation. My final question, not long after opening the business, you closed the deli operation. This resulted in a change of use at the premises requiring planning permission. And something, although requested by you, from the City of York Council, you have yet to apply for. You knowingly and willingly operate the business in breach of planning regulations. Why do you consider this acceptable?
Can I intercede? This is not a planning committee. This is regarding nuisance, and the fact that there may be or may not be a planning breach has got nothing to do with this committee.
Thank you, Councillor Galvin.
I understand Councillor Galvin's intervention, but if Ambiente choose to bring into question my character, then I suggest that by not applying for planning permission is indicative of their character.
Don't accept that, but there you go.
Okay. Thank you. Have you any further questions, Mr. Price? No. Okay.
No, I have no further questions.
Okay. Now to the members. Do you have any questions, Mr. Councillor Galvin, since you've already spoken?
No, Chair.
Councillor Myers?
Thank you, Chair. I should just ask a similar question to the licence holder about the Public Protection Officer's recommendations, specifically around a documented noise management plan and what the licence holder's view of submitting one of those is.
Yeah, thank you, Councillor Myers. I'll refer back to the original committee when we applied for the licence, and the condition 25/now 26 was discussed at that. And we did actually agree, from my memory, at that hearing, that it was an example of bad drafting on my behalf. That was actually a condition that I asked to be put into the license application. It's a standard condition that we use, but it was only ever meant to apply to the internal premises, i.e. that noise nuisance would be mitigated by the fact that all windows and doors would be closed, and that any noise or music from inside the premises would not be heard by the surrounding. It was never intended to cover the courtyard at all. We're in a courtyard next to 15 plus neighbours. There was never any going to be a question of a sort of tolerable annoyance, if that's the word if that's the phrase we're going to be used from there. So yes, I would fully support the suggestion from Public Protection to remove condition 26 and implement a noise management plan instead, that we would be happy to work with Public Protection on. So we got something that was acceptable to them.
Okay. Is that any more comments, Councillor Myers?
No, thank you,
Questions,
Chair.
I mean. Yes, I just have one small question. Is there any music played in the courtyard, or is it only just
No,
so it's just what comes
not,
out
no.
just by chance?
Yeah.
Okay, thank you very much. Thank you. Right. So I will now invite the parties to summarise their case. The parties will each have 5 minutes to summarise. We will hear it in the opposite order. So Ms. Sinclair first, followed by the review applicant, Mr. Price. So Ms. Sinclair, you've got 5 minutes to summarise.
Thank you. In summary, I'd just like to say that that there is no case to answer on public nuisance, but we would support Public Protection's motion to remove condition 26 and instead work with them on a noise management a noise management policy to go in its place. That's all I've got to say. Thank you.
Thank you. And Mr. Price, you too have 5 minutes to summarise.
Thank you, Chair. It goes without saying that a public nuisance is being created. That has been confirmed by the Public Protection Officer. And it equally goes without saying that Ambiente don't seem to understand the definition of a public nuisance. It can apply to an individual. At the beginning of their intention to take control of the premises in 2018, I met with Ambiente at my instigation to discuss with them what their expectations and aspirations of this business were. I expressed at the time that I was very concerned about the use of the backyard for part of a licensed premises. Unfortunately, although I can fully understand why, Ambiente chose to press on with using the rear yard as part of a licensed premises against not only my concerns, but those of a number of neighbours. In attempting to address those concerns, condition 25 is in the licence. I don't accept that it is badly drafted. The opportunity to correct any drafting and to specify that it didn't apply to the outside yard would have been and could have been and should have been taken at the hearing, and my recollection is that the chair was fully aware of what that condition said. Equally, if you take condition 25 out of the licence in relation to the use of the outside space, you are not left with anything that offers any protection whatsoever to residents about the control of noise. And therefore, I suggest that it is only right and proper that that condition remains in the licence. But equally, as I have said, condition 25, whether it's being breached or not being breached, to a certain extent is irrelevant. The issue here is that a public nuisance is being created and that needs to be addressed. I maintain that the conditions approved by the variation process only make matters worse. We have gone from an unlicensed outside yard of 8 people to 20 people, an increase of 150%. And Ambiente want to take out 4 of the controls that are supposed to control public nuisance. I find that unbelievable. So I continue to say what I have said at the very beginning, that this location does not lend itself to a licensed premises. My assertion is supported by the council, who have also said that this location should not be licensed, and supported by the public protection, by the Environmental Protection Unit, who have said that this area is not suitable for a licensed premises. I can only say that the last 3 years have been a very good trial period, but the experiment has failed. Thank you.
Okay, thank you, Mr. Price. Right. Are there any final points of clarification from the subcommittee?
Yes, I thought I'd read it here somewhere. What are the licensed hours of operation for service outside in the open area? I think that's probably, is it Miss or Mrs. Sinclair?
Yeah, thank you, Councillor Galvin. It's 11 a.m. to 7:30 p.m. daily, and the courtyard's to be cleared by 8 p.m.
Thought I'd seen it somewhere, but thank you very much.
Any more questions, Mr. Councillor Galvin?
No, I'm sorry, Anne, no.
No. And Councillor Myers, yeah. You shook your head. No.
No. No.
Okay.
Thank you, Chair.
Thank you. Right, so that the subcommittee will now withdraw to consider its decision in private session. We will not return to this public meeting to announce our decision today, so the parties are no longer required to remain in this meeting. The decision will be communicated in writing to all parties and announced on the council's website within 5 working days. So thank you very much, Mr. Price and Ms. Sinclair, for attending this hearing. And I'm sorry about the technical hitches at the start, but hopefully you feel we've listened to you. So thank you very much. Thank you. Good night.
Thank you. Good night.
Confirm the live stream's now ended.